This case management conference and joinder application hearing is in the matter of case number CFI 87-2022 and is being held by way of video conference before Justice Sir Jeremy Cooke, appearing from London. Any orders or directions made during or after the course of this hearing will be issued by the registry in Dubai on the judge's instructions. The claimant is represented by Horizons & Co. law firm. Lead counsel is Mr. Stephen Doherty. The defendant is represented by MB Kemp LLP. Lead counsel is Mr. Michael Pasha-Joyce. Will the judge and the parties' representatives please confirm that the situation is as I have stated?
Confirmed.
Confirmed.
Thank you, gentlemen. Thank you.
Very good. It's your application initially, Mr. Doherty, I think.
Yes, thank you, Your Honour. Of course, you'll have some familiarity with this case from the hearing back in April, and as I'll come on to, given what the relevant test for joinder says, it might be the case that there's not a huge amount of detail that needs walking through. I suspect, given the nature of the parties' positions, it may well be that there's more that I have to say in reply than I do initially. Obviously, that's going to be subject to what Mr. Pratchett-Joyce says in his submissions, but if at any point Your Honour feels there's a point you'd like me to address arising from what the defendant says, I'd be happy to pick that up at your convenience. Where I had proposed to start was with a few points by way of background, some of the specific details we might not have got into at the last hearing, which I'll deal with relatively briefly, because of course the broader background will hopefully be relatively familiar to Your Honour. The core document that we'll start with is at page 401 of the bundle. Where you should hopefully find a document titled Brokerage Services Agreement.
Yes.
I wonder if you could, Mr. Doherty, sorry, I wonder if you could provide references to which section it's in, because that would be helpful to me. Thank you.
Section D, tab 2, page 401. As I say, this is the Brokerage Services Agreement. So this is, and for convenience, I'm going to call them RELIC, which is the Cayman entity, and RELI-ME, which is the Middle Eastern entity. But first of all, towards the top of the page, we see the recitals. So he's explaining who the parties are. RELI Cayman is the life insurance broker based in Cayman, which is appointed as distributing agent for life insurance companies. And then below that, we have the explanation that RELI-ME is engaged in marketing and distributing life insurance products throughout the Middle East. So RELIC is the broker and RELI-ME markets and distributes those products within that particular region. And if we look at clauses 1 and 2, we can see, again, relatively straightforwardly, clause 1, provision of services. All services are carried out for the direct and exclusive benefit and burden of RELI Cayman for no other person. RELI-ME agrees to provide the services listed in Schedule A. RELI Cayman will provide administrative support, marketing support, referral, fee payment, and accounting services to RELI-ME. And then clause 2 provides for payment of some service fees. So RELI-ME are providing services in support of RELIC's brokerage business, and they get a service fee in return. If we scroll down this document to page 406, we can see those schedules. So first of all, 406 is the schedule setting out the services. I'm not going to go through all of those, but in short, it's marketing, consulting with referral sources and clients, assisting with structuring contracts, servicing policies after execution, so an after sales role. And then item 6, which is and over the page to 407, we've got Schedule B. which provides service fees. So there are two bases of calculation, but we've got either a percentage being paid, which is 28% of commissions received from insurance carriers, or it's 23%, depending on the particular type of transaction. And really the short points that arise from that document are, first, that the work of Relic and Relly.me are obviously intertwined, in that the Middle Eastern entity has been set up to support the brokerage business of the Cayman entity. It's effectively a regional offshoot that deals with its marketing, sales, after sales, and so on.
Yes.
And the second point is that where we have a cause of action that asserts that the defendant's actions in this case led to the withdrawal of referral sources and consequently a loss of commissions, that is a loss which is going to be borne by both entities. So around about 3/4 of the loss would lie with Relic, and 1/4 of the loss would be with Relly.me, because of the structure of how fees are paid out under this brokerage services agreement.
Yes.
And so it should be relatively obvious, I think, that the context in which this application for joinder is brought is so that the trial of the claim covers the whole of the loss suffered arising from the same incidents, and that
Yes.
loss has just been apportioned between two parties. And in a lot of respects, that is the core of it. I'll come on to a few more documents just to provide a bit more detail on that and the context in which the Relic claim arises more specifically. The first is the defendant's employment contract, which is just over the page again. So it starts at page 408.
Yeah.
And this is at the top of the employment letter. And I'm looking at the first substantive paragraph. The purpose of this letter, the agreement, is to set forth the terms upon which one or more members of the RE International Group proposes to engage you, as further set forth in Exhibit A to this agreement. And then it says the RE International Group.
I hesitate to interrupt my friend, but my friend is taking the court to the employment letter of November the 1st, 2018. And it was my understanding that there was a further employment letter and an updating of the employment contract. The employment letters are in different terms.
As I understand, well, two things, I suppose, for convenience. This shows what the defendant was entering into when he commenced his relationship with Relly.me and Relic. I think the second point is the term, as I understand it, or the term I'm referring to, is drafted in materially the same way across both letters. There are some changes in terms and conditions, but not in respect of this provision.
For the court's reference, the 2021 employment letter can be found at page D89 and following.
Yep.
And maybe we can go to that after if needs be. The point that I make about this is relatively brief, but it's the second sentence. The RE group of companies is comprised of its brokerage companies, and then it lists a number of entities.
Well, let me stop you there. It's common ground between the parties, is it not, that the employment contract is with RDL Middle East?
Yes.
That's common ground, and this is, so to speak, an introductory letter where the annex, in fact, is the relevant contract with the relevant company. Is that right?
Yes, I think there's a dispute between us about the contractual force of the letter. We say that the letter sets out terms of contract as well as the employment contract itself, and both make clear that the contracting entity is Relly Middle East. That's not in dispute. The purpose of
the only area where this gives rise to an issue is if we get into the factual question as to whether or not fiduciary duties may be owed elsewhere.
Yes,
that's what it's about.
Yes, and I'm not taking you to this to try and argue that there's a contractual relationship between Relly Cayman and the defendant.
No. Well, I think I can cut short a great deal of this. It's a matter for Mr. Patchett Joyce to try and persuade me that there isn't a factual dispute here in relation to the existence of fiduciary duties. I mean, that seems to me to be the key question in relation to joinder. And for the moment, it seems to me that there are factual issues which will inevitably arise. So you may be right, Mr. Doherty. The right thing to do is to reserve your gunpowder until we've heard Mr. Patrick Joyce.
Yes, I hope to have a steer from Your Honour on that position. You'll have seen that that's very much the ethos in which the skeleton, from our perspective, was drafted. And
yes,
the gloss we would add to that is to say we've had a hearing about whether there are factual issues that arise on questions of fiduciary duties, negligence, and so on. And we've had a decision on that. So there may even be a question about whether it's even open to the defendant to raise those arguments again. But it may well be that, as you said,
well, there's a different.
It.
It's a different company involved here, so there's a slightly different range of arguments. But as I see it at present, Mr. Patrick Joyce has persuaded me that the case is unarguable, that or next best thing at least, in relation to the existence of duties, common law and fiduciary duties owed to relic as opposed to reline.
Yes.
Why did you leave that point there for the moment, Mr. Doherty, and hear what Mr. Patrick Joyce has to say?
Yes, I can circle back to the employment letter and the effect of that if I need to. The other documents I was going to bring to Your Honour's attention were, again, factual documents which may have some bearing on those issues which go to whether there was fiduciary duty and what the defendant was doing. So these are the issues that were covered in Mr. Chin's third statement of paragraphs 9 to 12. And really, I just wanted to take you to the underlying documents and what they show.
Yes.
The page reference is section D, tab 5, page 642. So I actually think the page is 641. I've mistyped that in my own note.
Yes.
And this is one of 5 instances given in Mr. Chin's witness statement where we have, so I believe it's one of, sorry, forgive me, this is one of the 17 instances, first of all, given in Mr. Chin's statement of the defendant preparing these broker letters. So that is letters that are issued by the broker, who of course is Relic, to the insurance carrier. And you might recall this last time because we had this form of letter sent specifically in relation to the King Barnes transactions. But it's Mr. So-and-so was referred through the introduction of referral source who's known them for X number of years.
Just remind me who Mr. Parker is.
Mr. Parker is another of the first claimant's employees. But what Mr. Khan does here and on other occasions, including in the particular transaction of this case, is to sit down, prepare a draft letter that's to go from Relic to the insurance broker. Yeah. He sends this by email, and then if we go to page 600, I think the first example is page 608 of this same tab.
Yes.
This is indeed one of the King Barnes transactions based on the drafting provided by the defendant. We can see that's how this letter then goes out. So you can see at the top right of the page, it's being issued by Relic to Manulife Bermuda.
Yeah.
And then the next page I want to bring you on to is page 646. Which is another email chain. And once you have that, you should see it's a reply email from Cooke, but it's the second email down that I'm referring to from Mr. Khan.
Yes.
So this is one of the 5 instances we have in evidence already where Mr. Khan is involved in procuring the execution of referral agreements. So that's going to the referral agent, getting it signed, circulating the agreement. And for your reference, the other documents on that same issue are at so 646, 652, 653, 663, and I think 642. And one of the specific documents that the defendant procured the execution of was the referral agreement between King Barnes and Relic.
Yes.
Which we also have in evidence. And so just to pull those points together fairly quickly, we have Relly.me and its employees who provide services pursuant to the brokerage services agreement to its group company Relic. Relic and Relly.me then split the fees received from insurance carriers. I can come back to the contractual issues if we need to later, but in effect, the points that we would make about those that the employees are told when they sign their contracts, amongst other things, that the commissions that they receive are calculated by reference to what's received from the group companies in total, rather than the 23% that comes to Relly.me. And it's also,
Yes.
we say, obvious from their contracts that the services they're providing, although they're contractually bound to Relly.me, will require them to carry out services on behalf of other entities too.
Yes.
And what we have then on the facts, which the underlying documents show, is the defendant carrying out his responsibilities as part of his employment in, amongst other things, drafting letters that are going to go out from Relic and procuring the execution of agreements from referral sources that are then entered into by Relic. And given that the central issues in this case concern the defendant's actions in establishing a referral relationship between King Barnes and Relics, and the statements that he made, including when he drafted those broker letters setting out the supposed relationship between King Barnes and its end clients, and his involvement subsequently in procuring the execution of the referral agreement, we say that it should be fairly obvious that there is at least a core of a factual basis, which then needs to be investigated as to whether they give rise to, amongst other things, fiduciary duties, duties of negligence, whether they're actionable misrepresentations or fraudulent misrepresentations, and so on. So that, in a nutshell, is the joinder application. Your Honour, the other things that I proposed to take you to were the terms in which the particulars of claim has been proposed to be amended.
Yes.
And a few points about the test for joinder. As I say, I can defer and raise those issues later if you think that would be the most efficient way to proceed, or I can deal with them briefly now.
Well, you've seen what Mr. Patrick Joyce has said in his skeleton. So if you want to deal with something specific now, do.
Certainly. Well, I'll rattle through it reasonably quickly. The repleted particulars of claim, you'll find section A of the bundle starts at page 5. Oh, sorry, I've got that wrong. It's the section B of the bundle, tab 2, page 31.
Yeah.
Where you're on, you can see the red line. As you scroll through the first couple of pages, it's simply to set out who Relic is. After that, the pleading is substantively unamended until we get to page 47. Which is the section dealing with breach of fiduciary duty. And we can see that what's being added here is simply that the duty is owed to another party, but arising from the same factual circumstances. 49 is the beginning of the section on deceit, and which is again the same. It's adding relic onto that. But what we have, which is open to relic, but isn't open to reli me, is the alternative plea of misrepresentation. Because of course, relic here is the party that enters into a contract based on representations, whereas reli me does not. But otherwise, the factual premise giving rise to the claim is the same. At page 51, we have negligence. I should say I skip over breach of contract because there is no contract between relic and the defendant, so the contractual claim is unamended. But the negligence claim, again, arising from the same factual circumstances, but it adds relic into the mix. The long and the short of it is that the substantive case, the facts that need to be proved, the facts that are alleged, remain unchanged. And it's with those amendments in mind that Your Honour is asked to address what the legal test for joinder is. And at the outset, I think we make the point that this isn't a strikeout application, it isn't an immediate judgment application, nor, for that matter, is it the same as an amendment application, where one would ordinarily be applying strikeout principles. And I say that now in part because it's largely the way that the defendant has proceeded in framing its opposition to the joinder application. But the relevant test in RDC 20.7 is question 1, is it desirable to add the new party so that the court can resolve all matters in dispute in the proceedings? Or 2, there's an issue involving the new party and an existing party, which is connected to the matters in dispute in the proceedings, and it's desirable to add the new party so that the court can resolve that issue. And so we point out, first of all, the relatively low threshold we're actually dealing with here, and the extent to which it in reality entails a rigorous merits assessment. We say that that approach, of course, makes sense when we consider we're dealing with an interlocutory application, and that the new party, if added, still then has to go on and prove its case at trial. But we would also say it's at least implicit in the rules that there will often be cases where joinder applications aren't even really contentious at all. And we say that because Rule 20.3 makes express provision that an application can be dealt with without a hearing if the existing parties and the proposed new parties are in agreement, which is why, of course, the claimant sought that consent before it ended up making this application. What the defendant seems to have done is taken that as an invitation to now reopen the question of what is or is not a triable issue. And as pleased as I am that my learned friend enjoyed our last outing so much that we get to do it all again, and we say that that approach on a strict application of the test is misconceived anyway. And as I've alluded to it already, Your Honour, we've referred to at least the prospect or the question of whether there might be some form of issue estoppel or Henderson type abusive process. But I suppose the very simple point that we would refer to is paragraphs 25 and 26 of your judgment on this matter back in April. What you did say that it's clear on the basis of the pleadings that there are issues of fact which require to be determined, and that any application to strike out the claim cannot succeed. You went on to say at paragraph 26, in respect of the issues on summary judgment, fact and expert evidence would no doubt be required to make good the loss claimed, which falls to be set off against any commission, and so on. The point really is that those findings continue to apply, we say, with equal force and have not changed. At the last hearing, the defendant argued, of course, that it didn't owe fiduciary duties and tortious duties. But ultimately, it was held that those are questions of fact, or at the very least mixed questions of fact and law, and therefore for trial. And the same goes with the claims in deceit. And if that logic applies to the claim between the defendant and Relly Me, we say the same logic applies, and it should have been obvious that it applies to any claim brought by Relic, given the way that the proposed amended claim is pleaded. Indeed, the defendant itself seems to acknowledge that, because my learned friend's own skeleton argument at paragraph 54 points out that Article 158.3 of the Law of Obligations provides that in all other situations, it is a question of fact whether in all circumstances of a case a person is a fiduciary. So given that Your Honour has already decided that these are triable issues, the only question that is now before you is whether it's desirable to have those triable issues dealt with in the same set of proceedings. And that's what's required by Rule 20.7. There are short points of authority I've referred to, Your Honour, in my skeleton argument. So 2 cases. I don't think I need to pull them up because I can read from the very short extracts. But the first is the Grand Valley and Suntech decision on the 19th of May 2019. What paragraph 21 says is when determining whether it's desirable to add a new party, 2 lodestars are the policy objective of enabling parties to be heard if their rights may be affected by decision in the case, and the overriding objective. And amongst the factors relevant to the application of the overriding objective in that case included the fact that the addition of the party wouldn't cause any material delay in proceedings. Just for your note, that's paragraph 22C. And we would say that that's, in effect, the situation we're in now, given that the only substantive step taken in these proceedings so far is service of particulars of claim. We haven't yet got a plea of defence. There are going to be directions for that. The next case, again, it's a very short extract, is Nest Investments, which Your Honour will be familiar with. But the relevant part that we rely on here is paragraph 61. It's at page 771 for your note, but it's that desirability is informed by the objective set out in the rule itself, namely that the court can resolve a common issue between the new party as well as the existing parties. That avoids inconsistency, additional costs, and work involved in more than one set of proceedings. So one of the benefits of joinder and the purpose of the rule is to avoid duplication of work and costs and the potential inconsistency of judgments that would otherwise occur if there are parallel or fragmented proceedings when actually we're dealing with a common issue. And we say that when you apply that test at 20.7 to this case, it's plainly desirable that Relic should be added. Because first of all, it's got a strong financial interest in the claim, obviously given that it's borne some 75% of the losses arising from the alleged breaches of duty, which are common to Relic. Second, the breaches of duty that Relic relies upon, as you've seen in the proposed amended particulars of claim, arise from the same factual circumstances and breaches that Relic are already relying on, namely the circumstances surrounding the execution of the King Barn referral agreement and how those transactions came about. So following that approach in Nest, it's desirable, we say, that those issues should be tried together to avoid inconsistency and additional costs. Third, as is the case with Relic, the existence of those various fiduciary duties and so on, if disputed by the defendant, can only be established following investigation of facts at trial. And if the court is going to go to the lengths of examining the existence of duties between the defendant and Relic, it would be efficient and proportionate in light of those investigations to then go on and determine whether similar duties existed as between the defendant and Relic. And Your Honour, I've already taken you to what we say is strong prima facie evidence for the existence of those duties, namely the defendant's involvement in executing contractual terms entered into by group companies, drafting letters on their behalf, and so on. And the final point simply is that Relic's pleaded claim arises from precisely the same set of facts and circumstances as Relly Me's claims. And given the way that the case is pleaded, there isn't an additional burden on the defendant in defending this claim, particularly where the application for joinder has been made at this early stage of proceedings before defence has even been drafted. And it's probably also worth highlighting that Relic and Relly Me have common legal representation. So there isn't really even a cost issue at play here. Those are the substantive submissions. There were a couple of relatively short points just before I hand over to my learned friend. The first is on the timing of the application, which I've addressed. Can I just check, Your Honour, there your video feed is?
Yes, I'm still here.
I just want to make sure you can still hear me.
Yes, thank you.
Thank you. As I say, the first point is on the timing of the application. And really, this is just to point out something that was said by Justice Giles when he was dealing with Nest at first instance, which is, of course, if you have an ongoing strikeout application and you want to make an application for joinder, you ought to wait until after the strikeout is dealt with, because otherwise you might end up trying to join a party to proceedings that cease to exist, which explains why the joinder application was issued early on when this round of pleadings came up and after we dealt with all of the joined applications back in April. The second point is on jurisdiction. I won't address it at any length at this point. Really, there are two short points. The first is we say that clearly on the basis of the facts pleaded, i.e. that the defendant was employed by a DIFC entity and physically worked inside the DIFC, and in circumstances where the factual issues, including the execution of referral agreements, took place within the geographical limits of the DIFC, one can get through three of the primary JAL gateways here. One, because the claims arise from incidents wholly or partly performed in the DIFC. Two, because the referral agreement with Kingsbarns was partly concluded or finalised within the DIFC. And three, because the alleged breaches took place within the geographical confines of the DIFC, we have a situation where the law of obligations applies to those incidents, and therefore we're dealing with breaches of DIFC laws or regulations. That, we say, is the primary footing that this claim by Relic is one in which the DIFC courts would enjoy substantive jurisdiction over anyway. But the second point is, as will be well known to your having been involved in the Nest decision, Rule 20.7, if you deem the conditions are satisfied, gives rise to jurisdiction anyway. So whatever way you look at it, provided you're happy that it's desirable to join Relic, there are no jurisdictional issues that the court ought to be concerned with.
Well, the point that's taken against you relates to the Hong Kong jurisdiction element in the letter that precedes the contract of employment there, doesn't it?
Yes, although in my respectful submission, it's a slightly odd point because it's common ground, and indeed my learned friend relies on the fact that there's no contract between Relic and the defendant. And if there's no contract between Relic and the defendant, then whatever the import of that jurisdiction clause is, it doesn't apply to Relic. It can only apply as between Relly, me, and the defendant. So there's no way of saying that Relic intended that that the Hong Kong court should have jurisdiction, because there can't be a contractually binding jurisdiction provision between Relic and the defendant.
The question is whether it's your case that you rely on a contract with Relic at all. The reference that Mr. Patrick Joyce makes is to paragraph 5 of the particulars of a claim, isn't it? You talk about two agreements.
Yes, Your Honour.
Yes, so I can come back, as I said, to the employment letter. The short point is that the employment letter is a contract. It's part of the contractual terms between the defendant and Relly Me. We know that because Schedule A to the employment letter says you are employed by Relly Me.
Yes.
The significance of referring to the other group companies in that context has a number of different edges to it, but just to read out what that provision that's relied on says in very short order. It lists the entities, which includes the Cayman entities and others, and it says collectively the company. And that term, the company, appears in a number of places throughout the contract. But for example, in the schedule of services to be performed for Relly Me under the employment agreement, it says you will assist with managing the capital C company's referral sources. In other words, whilst you're contractually engaged with Relly Me, you're expected to perform services that are going to interlink with other group entities. And the same point cuts both ways, because if you look at the commission provisions in the contract, they are defined by reference to net revenues received by the capital C company. In other words, it's the net fees received from the insurance provider, but before they're apportioned off between Relic and Relly Me. That's obviously going to be potentially significant for the defendant, because his current case, his current expectation, the way that he's previously been paid commission, has been on the basis of what has been received by Relly as a whole, not by the 23 or 28% received by Relly Me. So we don't rely on the provision as creating any contractual relationship. What it does is it frames the circumstances in which non-contractual duties can arise. I hope that's a relatively succinct explanation of the points we make about that. As I say, I'm happy to field any questions that Your Honour might have about that, or revisit in reply if you think that's a more efficient way of proceeding.
All right.
The very short and overarching point is that whatever way one looks at it, there are factual issues here which are relevant to the existence and scope of the duties alleged. Those are matters for trial. They arise from common issues, and so it's desirable that the joinder take place.
Yes. Thank you. Mr. Patrick Joyce.
Your Honour, I'm obliged. And I hope to get back to full screen if I can. Yes, I'm obliged. Your Honour, what I intend to do is make some initial nutshell points. I then will go back to my skeleton and summarise what is set out there. The first nutshell point is to go back to the rules of the DIFC courts. I'm afraid I don't know whether it's common to everybody, but your screen is changing from light to dark and then to green background and then dark again.
It's semi-frozen and doing strange things, but I can
it's
hear
now
you.
Purple.
Well, that's very pleasant, but I can see you both and hear you both perfectly well. Okay. My own little screen of myself in the corner is doing all the things you say, sort of semi-freezes and then goes different colours. But I should just quietly ignore that unless I interrupt you.
I'm obliged. I might, in those circumstances, go back to simply having a little thumbnail in the bottom right-hand corner,
Yes.
because it's rather distracting with all the
Yes.
flashing on the screen.
I agree. I don't know why it should be doing that, but there it is.
Well, my apologies. I hope that that's a convenient way of proceeding, and I hope you can see me. I'm sorry if my eye line is sometimes distracted to the thumbnail at the bottom of the screen, but I'll do my best, Ronna. Well, let me start all over again. Let me begin with the nutshell points that in my submission are important for the court to consider. The test is absolutely common between us. It is RDC Rule 20, Sub-Rule 7.
Yeah.
And the question is of desirability. Our case, Your Honour, is that it is simply not desirable to add a party that has no case. The second bullet point is that one cannot, in our submission, do what the claimant and now relic is seeking to do, and that is to roll over a claim which the claimant is pursuing in favour of a different party, simply by tacking that party on at various points in the amended particular, the proposed draft repleaded amended particulars of claim, simply by tacking on and or, in this instance, relic, in the course of the pleading. And the particular importance of that is, although I haven't referred to it expressly in the skeleton argument, Your Honour will be fully aware of the provisions of RDC Rule 17.43. And Rule 17.43 says that a party must specifically set out the matters in his statement of case where he wishes to rely on them in support of his case. Point 1, full and specific details of any allegation of fraud, dishonesty, malice, or illegality. Sub-Rule 2, details of any misrepresentation. Sub-Rule 3, details of all breaches of trust. And the specificity is expressly required in relation to each and every one of those items, which for present purposes are the relevant aspects of Rule 17.43. And it's established in case law. It isn't in the bundle, but it can be provided. It's a case called Carmil, K-A-A-M-I-L, against Kawa, K-A-A-W-A, and others, which is Court of First Instance order made on the 22nd of December 2021, which says in terms, in my judgment, RDC Rule 17.431 in that instance requires full and specific details of the allegation, which is to say that a claimant should explain his claim with as much detail as possible. So, Your Honour, we must work on the basis that what is set out in the amended particulars of claim sets out the proposed case which relic seeks to advance with as much detail as possible. And Your Honour has had the opportunity of looking at my skeleton argument. For the reasons set out therein, we say that it cannot possibly be an exceptional case outside of the archetypal range of cases where a fiduciary duty arises between relic and the defendant. And if that is to be the case, then it cannot simply be a case which is raised by tacking on relic, because the circumstances as between Relic and my client are very different from the circumstances between Relime or Relimini and my client. And this again is fully explained in our skeleton argument as to why we draw the difference. And indeed, Your Honour is well aware of the fact that there is a difference, because when the point was put by my learned friend that there had already been a decision on whether factual duties arise, Your Honour rightly drew attention to the fact that a different company is involved here. And that answers my learned friend's points in relation to issue estoppel or Henderson and Henderson. It is in our submission quite impossible to suggest that there can be issue estoppel or Henderson and Henderson limitations arising, really it's the same point, in relation to a different company where very different considerations apply. What is it that takes this situation out of the archetypal circumstance which is described in Kelly and Baker and in all cases to which that case refers? Your Honour, if my learned friend is going to say that there is something exceptional, if my learned friend is going to say that a fiduciary duty arises not only under the statute of the law of obligations, which is itself exceptional to the common law, by creating a fiduciary duty between employee and employer, in our submission, he must go further and explain in the pleaded case why it is said that a duty is owed in these circumstances, not between employee and employer, but between employee and the 100% shareholder of the employer, which is itself not even a pleaded fact on the face of the amended or the proposed repleaded amended particulars of claim. There must be particularity. There must be specificity as required under RDC 17.43. And in our submission, there is absolutely nothing on the face of this proposed draft amended or draft repleaded amended particulars of claim which begins to explain why this is such an exceptional case. And on that basis, Your Honour, looking at the pleaded case, there is not even the basis for a fiduciary relationship being established. And that's why we say categorically it must fail. And that goes back to the starting point that it is not desirable to add a party that has no case. So far as deceit and misrepresentation is concerned, Your Honour will have seen, again in the course of our skeleton argument, that we've gone back and analysed the way in which the case is proposed to be put in the proposed pleading. There is one prior representation, which is that King Bonds wished to do business with ourselves, and that, as we say, is a true representation. And there is a further representation that the source of the referral was Imani Wealth. Now that was not right. Mr. Khan says that it was accidental and that it was unintended, but he acknowledges that it wasn't accurate, but it was accidental. The claimant says that that is a lie. But as we say in the skeleton argument, we don't need to resolve that for present purposes, because the focus of attention here is on Relic and not on Reline. If the claimant, or sorry, if Relic is going to be joined as a claimant, then it must go much further than what is said by an employee to his employer, because it is absolutely clear. We can look at this, but it's essentially paragraphs 17. This is page B38. It may be sensible to look at it now. Page B38, which is paragraph 17 of the proposed draft amended repleaded particulars of claim. Paragraph 17 pleads the email that my client sent to other Relime employees, sets out the points in that letter. Then paragraph 18 and 19 we don't need to worry about, nor 20 and 21 going over the page to B39. But at paragraph 22, it's pleaded subsequently on the 8th of August 2022, following the completion of due diligence and compliance checks by Relime, Relic, in reliance upon the defendant's prior representations, at which I interpose the defendant did not make to Relic, entered into a referral agreement with King Barnes, the referral agreement. Now, we know that the defendant sent the email to other employees in Relic. We know nothing beyond that in the pleaded case. How does something said by the defendant to others in the claimant come to be known to Relic? Who said what? To whom? When was it said? Why is it said that something which was said to Relime, which prompted Relime, as we know from paragraph 22, to undertake due diligence and compliance checks? Why did something which was said which caused those checks to be undertaken continue to have currency after the completion of those checks, as to which we know nothing about, and which again we know nothing about what Relic was told by others in Relime? Your Honour, the deceit and misrepresentation, which again needs to be pleaded with full and specific details, falls short, not just marginally short, but short by a very substantial margin. For negligence, there needs to be a special relationship. Where is the special relationship between a 100% shareholder of a company and an ordinary, albeit quite senior employee within that company? There is no factual basis for the establishment of such a special relationship laid at any point in these amended, particularly the proposed amended, repleaded particulars of claim. So, Your Honour, in a nutshell, whether one looks at it from the perspective of a fiduciary relationship between Relic and my client, or the existence of a case in deceit and misrepresentation as between Relic and my client, and whether one looks at it in the case of negligence, each and every aspect falls short, not by a simple margin, but by an enormous margin. One's tempted to use the phrase, it falls woefully short. Been trying to avoid using what is the usual adjective applied to something which falls short. But in this case, it does, Your Honour. It falls woefully short. Well, I'll come back to make good what I say by reference to my skeleton argument, which you've had the benefit of reading. Let me turn to some of the points which arise from my learned friend's skeleton argument. In our submission, the case which is now being sought to be brought by not only Relime but Relic should be seen for what it is. And in our submission, it is an attempt, perhaps a somewhat clumsy attempt, to harass the defendant procedurally. And I'd invite the court in this regard to look at the timing. It's clear from my learned friend's skeleton, which begins at page G690. Sorry, it begins at page G686. And I'd take the court to G688 to begin with. At the foot of that page, Your Honour can see that claimant filed its particulars of claim, the repleaded claim, on the 29th of May 2023. Going over the page to G689, on exactly the same date, the claimant wrote to the defendant seeking its consent to the joinder of Relic. If one then goes on to page G691 at paragraph 16, my learned friend says as follows: the timing of the joinder application is appropriate. He refers to Nest and the comment by Mr. Justice Giles, or Justice Giles at paragraph 18, which he's already taken the court to this morning. He says, C therefore properly filed the application after the various strikeout and immediate judgments made by the parties had been heard and determined. Well, the determination of those matters occurred on the 28th of April. So my learned friend had between the 28th of April and the 29th of May to think through what is now being brought before the court. And plainly, he must, or the legal representatives of the claimant and Relic must have thought this through. You couldn't serve a document in draft amend, or you couldn't replead the particulars of claim, serve it on the same day, and then within the same working day say, oh, we'd like to join. It can't have been a thought which occurred during the course of the 29th of May. It's a course which must have been under consideration from the 28th of April, if not before. And Your Honour, when one sees what's acknowledged in paragraph 6 and 7 of my learned friend's skeleton, it is in our submission obvious that what the claimant and Relic were seeking to do was simply to bide their time to make a further attempt to harass the defendant procedurally. Your Honour, just taking a few points from my learned friend's skeleton, at paragraph 21D, paragraph 21D is on page G693, and it is part of a list which my learned friend says makes it plainly desirable to add Relic. In any event, he says at the top of page 693, in any event, there are strong prima facie grounds giving rise to the existence of duties relied upon by Relic, not least that D's contract of employment provided that although he was employed by Relime, it, quotes, set forth the terms upon which one or more members of R.E. Lee International, etc., and then there is a considerable extract. Your Honour, this points up the problem that the defendant has with regard to what is the contract that my learned friend is relying on, because here he says in terms it's the defendant's contract of employment. With respect, what he has then set out is not from the defendant's contract of employment. It is the opening paragraph of the employment letter, the proper version of which can be found on page D89. So is my learned friend, as he appears to be, and as Your Honour has rightly pointed out to my learned friend in the course of his argument, is he saying that my client was employed under the employment letter and the employment contract, which he seems to say for some purposes? Or is he saying that my client was only employed under the employment contract, which he seems to be saying for other purposes? So Your Honour, my learned friend seeks to rely on the employment letter when it serves his purpose. It says it's part of the contract of employment. But if that is so, as we have pointed out in our skeleton argument, if that's so, the employment letter contains jurisdictional provisions and governing law provisions which are expressly said to trump the employment contract. In the event of disparity or discrepancy, the term of the employment letter applies. And that means, as we say in our skeleton argument, that there is a choice of law and choice of jurisdiction. Choice of jurisdiction is the courts of the Hong Kong Special Administrative Region. Choice of law is Hong Kong law. Learned friend cannot run with the fox and hunt with the hounds. And that is precisely what he is seeking to do between his skeleton argument for today's purposes and his amended or repleaded amended particulars of claim, which we see at page B31. There is no clarity at all in the way in which the learned friend is putting his case. And it's frankly not good enough to say, well, there are lots of factual issues so far as relic is concerned, and they're really the same factual issues as reline. That in relation to relic is simply Micawberism. It is simply putting off to the hearing that which needs to be pleaded with specificity, namely how their case is put. It must be consistent, it must be clear, and it must conform and comply with RDC 17.43. My learned friend at paragraph 24A, this is a point really which I've covered, but it emerges in his skeleton at 24A. This is G694. This is the relic's case being contingent on establishing that it was owed various fiduciary and tortious duties by the defendant and that those duties were breached. And then he goes on to make the point that he has made and I've answered, namely that submissions have been made, and he puts this as a second attempt, and that it remains desirable for relic to be added. That wholly misses the point. The point I've made, a point that Your Honour has, namely that last time round it was relime, this time round it is relic, and they cannot simply be equated on a roll-over, tacked-on basis.
Can I ask you a question, Mr. Patrick Joyce?
Yes, Your Honour.
Suppose Mr. Doherty wants to rely upon the letter of employment as opposed to the employment contract. You say he has to go to Hong Kong to do that. If indeed I was to follow that line of argument, say you must go to Hong Kong, and he then does that and goes off to Hong Kong, the end result would be that there would be two sets of proceedings going in relation to much the same facts. subject to all the arguments about differences between them in relation to fiduciary duties and so on and so forth, which on the face of it would appear to be disadvantageous, uneconomic and inefficient for both parties. Taking a long-term view of the matter, if that were to happen, it would then be sensible for the parties to agree to have both sets of proceedings heard in one jurisdiction or the other. I take it you have no instructions about that.
Well, Your Honour, the point is answered with respect on the face of the documents. Could I take Your Honour to page D93?
But that's, as I understand it, no, sorry, let me find 93 first.
Reference for that.
It is not. It is 90. The overall page is 93.
All right. Thank you.
You're looking at paragraph 6 and paragraph 12.
I am, Your Honour. And
yes.
In particular, I'm looking at the last sentence of paragraph 6.
Yes.
You and the company agree that in the event of a conflict between the provisions of this agreement and the DIFC agreement, unless otherwise required by DIFC employment laws defined in the DIFC agreement, this agreement shall prevail. So,
well, I understand that. But isn't the position that under DIFC employment law you can't opt out of DIFC employment law in relation to a DIFC employment contract?
Well,
Am I not right?
We're not opting out of DIFC employment law. It is where that law is applied. Its governing law is clear, but jurisdiction is also clear, and that is covered here by clause 12. It would fall to the Hong Kong Special Administrative Region Courts to apply DIFC law, because that's essentially what clause 12 says, that it would be justiciable in front of the Hong Kong Special Administrative Regional Court.
Just get your submissions clear about this. I hadn't understood you to be taking a jurisdictional point in relation to, and indeed it may be too late to do so, in relation to any claim that is brought under the employment contract, the DIFC employment contract. Am I right about that?
We say that the only contractual document is the employment contract, that the employment law, the employment letter is not contractual, and
yes.
On that basis, in a claim brought by Relime, the claimant, on the basis that only the employment contract applies, the DIFC courts clearly have jurisdiction.
Yes.
And my client wants, in that context, for the DIFC courts to have jurisdiction, because he will be bringing a counterclaim. The confusion is that my learned friend, as I've said previously, Your Honour, wishes to run with the fox and hunt with the hounds, and he is relying only on the employment contract when it suits him, and then when he wants to bring in as a contractual provision the employment letter, he brings in the employment letter, and that's where there's a difference.
I've got that point entirely, which is why I asked you the question that if I was to accept that submission and Mr. Doherty then goes off to Hong Kong and begins proceedings in Hong Kong under the letter, we then have two sets of proceedings, one under the letter in Hong Kong and one under the employment contract in the DIFC, which of course makes a nonsense in one sense because it's inefficient and so on. Yeah. Parties may see forensic advantage, procedural advantage, tactical advantage in doing that in order to try and exert leverage on the other party, but no court is likely to look on that as a very good idea.
Yeah.
And in all probability, one court, if it had no power to do anything else, would stay its own proceedings to await the result of the other. But it's a nonsense on the face of it, which is why I asked you whether you had any instructions as to what would be the position, what stance your client would take, were that to happen.
Well, Your Honour, let's follow the sequence that Your Honour has placed before me through. And it begins with the point that if there are, looking at the jurisdiction clause, two different actions, one under the letter of employment in Hong Kong and one under the employment contract in the DIFC. And Your Honour says, well, that's obviously plainly disadvantageous, it's inefficient, and that we should avoid that if at all possible. Well, Your Honour, the first point is that the claimant and Relic are the author of this problem, because they are the ones who've written the letter of the employment letter and the employment contract. But really, it comes back to what I've said in paragraphs 40 and 41 of my skeleton at page G710. And if I can take Your Honour to those paragraphs. This is, of course, at the end of the quite extensive discussion setting out the terms of the employment letter beginning at paragraph 30 going through to paragraph 33. Similarly, with regard to the employment contract 34, the analysis begins at paragraph 35, but then I think the answer is really in paragraphs 40 and 41. Top of page G710. In other words, if claimant were right in its pleaded case, which is going back to paragraph 5 that Your Honour has firmly in mind, if the claimant were right in its pleaded case, the DIFC courts should have no jurisdiction. A fortiori, the DIFC courts have no jurisdiction over any claim that Relic might seek to bring. Relic does not have the benefit of an express jurisdiction clause conferring jurisdiction on the DIFC courts, and the strong indication, and I put it deliberately in those terms because of the non-contractual effect in our submission of the employment letter, the strong indication is that insofar as any dispute might arise between Relic and the defendant, and of course that plainly applies to breaches of fiduciary duty, and indeed, because there is no claim brought in contract, in fact, any claim brought by Relic must be under the employment letter, because, as my learned friend rightly concedes, there is no contractual basis for Relic to bring any action against my client. So whether one looks at it in terms of fiduciary duty, deceit, misrepresentation, or negligence, then the provisions of clause 12 in the employment letter is the governing provision so far as Relic is concerned. So actually it is more than a strong indication. But insofar as any dispute might arise between Relic and the defendant, those parties had manifested a clear intention that the governing jurisdiction should be the Hong Kong SAR courts. On the basis that the employment contract is the only contractual document, as between C and D, the DIFC courts have jurisdiction. DIFC courts have no jurisdiction over issues, if any, between Relic and D, and or should exercise their discretion to decline jurisdiction. And therefore, what my learned friend can do would be to rely on the, well, no, then we have an interesting position, which I would await to see what my learned friend does. But essentially, if there is to be any sort of consolidation in any jurisdiction, then in my submission, the prime candidate is in front of the Hong Kong courts on the basis of the material that we have here. not the DIFC courts.
I think there's a problem with that, isn't there? Maybe I'm misremembering and someone can put me right. But I thought the DIFC law did not allow for opting out of DIFC law in the context of DIFC employment contracts. But you say that
we're not opting out of the law. We're opting it's the jurisdiction. It's right. Where that law is applied.
Can you just direct me for a moment to the place in the bundle where I find the employment contract?
Yes, the employment contract is at D10102.
D102. Okay.
And the governing law and jurisdiction clause is clause 28, which is D111.
Yeah. And for the purpose of any of the commissions that you seek, you need only rely on this. It's identical, in fact, is it, to the letter in relation to the different tiers of commission and so on, first tier commission, second tier commission and so on?
Yes, so far as I'm aware.
Yes. I haven't been through that in any detail, but
no, so far as I'm aware, that's true.
I'm looking ahead, Mr. Patch-Joyce. Your counterclaim will be based solely upon this document and nothing else. Is that right?
Well, it will be based on the document plus all of the supporting documents which we have been seeking and which we have not yet got. But with that clarification, yes.
Your contractual rights are based entirely on this document and nothing else.
Yes.
Yeah. Okay. Understood.
Or I'm not too sure where I reached, but it was helpful to go into that.
I'm sorry, because... I interrupted.
No, because it is very helpful in that it highlights 2 points. One is that the claimant and relic, or the rely group, however you term it, is really the author of all of these problems. The second point is that it really behoves Relime, first of all, to set out its case with absolute clarity. And we simply don't know. This is the article, this is the clause, the paragraph 5 point. We simply don't know how even Relime is putting its case. But if Relic comes along, it cannot then piggyback on the back of complete lack of clarity so far as Relime is concerned and say, oh, well, me too. And that is the position that the defendant is being put into by the way in which the claimant, first of all, and now Relic, is seeking to plead its case. It's just wrong.
Yeah, go on.
But Your Honour, just again, very briefly to deal with Malone Friend point at paragraph 25. This again assumes that there are causes of action which exist in favour of Relic. And it's back to the lack of particularity, no evidence of reliance, etc., etc. So yes, there are gateways, but there are only gateways if there is a cause of action. And we're taking the point at an earlier stage. We are saying on the face of the proposed, repleaded, amended particulars of claim, the document dated the 5th of June 2023, there is no viable pleaded case so far as Relic is concerned. And if there is no viable pleaded case so far as Relic is concerned, then plainly Rule 20.7 is not satisfied, because it's not desirable to join a party which has no case, and therefore the gateways simply fall away. We do not get to the gateways because of what we are faced with and confronted with in this amended pleading. Your Honour, I've probably covered quite a lot of the ground that is set out in my skeleton argument, but let me just take the court as quickly as I can through the skeleton argument to make sure that everything has been covered. The skeleton argument begins at page G700.
I've got a printed copy, yeah.
And I have too, so I'll take Your Honour through the printed copy. And the first point I should alert the court to is that when you get to the suggested pre-reading and the second witness statement of Mr. Lowe, all the C references are, I am afraid, out by about 36 or 37 pages. The reason for that is because at the time that the skeletons were being prepared, and I'm sure my learned friend found exactly the same problem, the amended particulars of claim, which found their way in as B31 and following, had not been uploaded to the court system. So once that omission was remedied, B31, 32 successive numbers continued, and that which had started as C31 in the version that I was working off, subsequent to the drafting of the skeleton argument, was displaced by the number of pages of the missing document or documents in section B. So I apologise. All references to section C, D, E, etc. are out, but it's not because I was being obtuse. It was because I was doing the best that I could with the material available. And of course, if they'd been, if the additional documents had been lettered instead of numbered, then the original numbering would have held good. But I apologise, and I point that out to the court. If the court wishes, I can supply a configured skeleton argument, simply putting in the appropriate page references to the bundle that's presently before the court. I'm happy to do that. I wouldn't alter the substance. I would just give the proper page references.
I don't think you need to do that. I'm well aware of the problems that arise. I've made a note, 36 or 37 pages out. Fine.
About that, yes. And it varies a little bit. In some instances, it actually goes back to 31 to 32, but it's somewhere around about 30 to 36 or 37 pages out. You just need to add that number on. And I'm very grateful to the court for sparing me the laborious job of having to reconfigure every reference. Introduction, I don't need to, this is G701, I don't need to trouble the court with that. The evidence, I don't need to trouble the court with that. Jurisdiction, my learned friend seemed at one stage to suggest that I had not had in mind the appropriate test. He said the relevant test is RDC 20.7. What the defendant seems to have done is to attempt to reopen the point. Well, Your Honour can be absolutely sure that I had the proper test in mind. It's set out in paragraph 5 of the skeleton. Paragraph 6 anticipates the conclusion that is indeed reached in paragraph 102, namely that neither limb of RDC 20.7 is satisfied. Your Honour, the procedural history is relevant for other matters. Malone and Friends' attempt to reopen the costs order of the 28th of April, and also the need, which has yet to be met, for Malone and Friend to plead an amended claim form to cover the points which had arisen on the 28th of April, not the amended claim form which Malone and Friend has put in simply to tack on relic, relic in addition to reline. There was a different point, but those are all made out in paragraphs 7 through to 21. And I'll take the court back to those paragraphs at the appropriate time. The scheme of the claim, this is taken from pages A5 to A28, and one then goes on to paragraphs 23 and 24, which set out the extent, the very, very limited extent to which it is sought to, as I put it here, tack on relic to the original, not the original, to the amended, repleaded particulars of claim. Evidence, I don't think the court need detain itself unduly on the evidence. It's mainly on law, as indeed the evidence made clear. Then we identify in paragraph 28 the various keys which we say are central to the court's consideration of this point. We begin by setting out the relevant terms of the employment letter, which Your Honour can see page G707 over the page to G708, paragraphs 30 to 33. We do the same with the employment contract at paragraph 34. We analyse and make good our argument that the employment letter is of no contractual effect for the reasons really identified clearly in paragraph 37 of the skeleton. The consequences of that are set out in paragraphs 38 through to 41, and we then come on to consider the heads of claim in paragraph 42. Your Honours had the benefit of reading the skeleton. Your Honours had got the benefit of the cases referred to in the skeleton. And what I tried to do was set out in the skeleton the relevant passages from the cases. So I'll perhaps just page reference the cases for Your Honour's ease of reference, but then take it as read from what is set out in the skeleton argument. Kelly is obviously a recent case of Mrs. Justice Cockerell. That is to be found at section I number 4 between pages 1093 to 1144, and the particular paragraphs which I've referred to, 17 to 33, are found at section I 1095 to I 1099. The cases
I really don't see how that's going to help me here, Mr. Patrick Joyce. You know, every case about fiduciary duty turns on facts. Other cases, you know, say where a principle is being set out, are really not of any great materiality, are they?
Well, I'm happy to take that, but Kelly is particularly important because what it does demonstrate is that it was a case not of fiduciary duties owed by a director to a company, but a case of a director owing fiduciary duties to a shareholder.
Well, I've got that, but this isn't just a shareholder case here, because of the peculiarity of the services agreement and the brokerage arrangements and so on. Because Reline can't operate as a broker in the DIFC, we have a broker that's outside the DIFC in the Cayman Islands, and we have someone who does some marketing in the DIFC. Yes. And to be frank, Mr. Joyce, I don't see how I could at this stage say that a fiduciary relationship is unarguable. So I think you ought to proceed on the basis that that's what I'm going to find, unless you have some killer point that I've missed.
Well, with respect, we do say that you cannot find on the pleaded case that there is a fiduciary relationship, because there is no specificity about how the fiduciary relationship arose on these particular facts.
I understand the force of that point in relation to misrepresentations and the pleaded case there, but I don't see the point, I'm bound to say, in relation to fiduciary relationship as such.
Well,
I don't know if that helps you to address your. I don't know if that helps you to address your arguments or not.
Well, it does in part, because it means that Sisyphus has a slightly shallower incline in relation to misrepresentation than in relation to fiduciary duty. But I do renew and repeat, I don't wish to weary the court, but I do wish to put my case absolutely clearly that for the reasons that we have set out very extensively, and I apologize if it's too extensive, but we've taken Kelly and looked at that and applied that to the facts of this case. We've then taken fiduciary duties under the laws of the DIFC, which is set out in the next section, including the case of Raul Silva and the clear cautionary note sounded by Chief Justice Huang in that case. And we draw those strands together really at paragraphs 60 and 61, where we G714, the position therefore is or should be that employees owe less onerous fiduciary duties than directors, and directors owe fiduciary duties to their company and only exceptionally to shareholders. Here, and then you have the point. And we say, look, it may be possible, Your Honour, I'm not saying that it is, but it may be possible for my learned friend to plead a fuller and clearer case which sets out the fiduciary duty. But that is what he must do. And what we've got won't do. And it won't do because of RDC Rule 1743, Subrule 3. He has to specifically set out details of all breaches of trust and confidence, and therefore he has to establish that there is a relationship of trust and confidence on these facts. And simply bolting on and or relic at various points in the amended particulars of claim, I renew my submission, won't do. But I'll leave it at that juncture, because the conclusion that we urge upon the court is set out at paragraph 62. And we do say that the plea is doomed to fail. But Your Honour will have to go back and look at the proposed amended repleaded particulars of claim and look at that against what we say needs to be drafted in accordance with Rule 1743 and come to a view. But in my submission, the view really can only reach one conclusion. I then turn to deceit and misrepresentation. And again, Your Honour, I've set out the pleaded representations is plural as how it's put. But if Your Honour goes back to look at, again, the way in which it's put in the amended particulars of claim, or the draft proposed claim, it's paragraphs 17 through to 22, and really there's only one representation set out there. We deal with that paragraph 64 and 65. Again, I've made the submissions that we don't need to resolve for present purposes whether it was accidental and unintended or a deliberate lie, because what we are told in the claimant's pleaded case is that Relime conducted due diligence and compliance checks on King Barnes in or around July or October 2022. And what we must be told in the pleading is what were the due diligence and compliance checks which were carried out, and why in those circumstances any representation endured beyond the carrying out of those due diligence and compliance checks, when the representation only went to the source of the referral, and it was overtaken by events of due diligence and compliance checks into the referred party. And this comes back to questions of knowledge and reliance, which we set out in the remainder of this substantial section, though there are several subsections which we go to. So paragraph 67, claimant relied on what Mr. Khan said only to undertake due diligence and compliance checks, didn't rely on what Mr. Khan said beyond that. The due diligence and compliance checks formed part of the claimant's obligations and responsibilities to Relic under the services agreement. And we say it's therefore unsustainable, and we don't shy away from putting it in these categoric terms. It is, Your Honour, simply unsustainable to argue that a comment about the source of a referral can continue as an operative representation in the face of due diligence and compliance checks. Then paragraph 22, which I've already taken you to. Paragraph 70. Not only does this aspect of the case hinge on the perverse argument that Relic set no store whatever by the checks for which it had retained claimant, but further hinges on an argument that it relied instead on what had been said about the source of the referral to claimant, not Relic. The only way in which Relic could have found out about what the defendant had said to claimant would be if claimant told Relic, in which case claimant must have adopted what was said as its own. And of course, the referral, which you've seen from the email, was to other members of staff within Relime whose responsibility it was, not the claimant, not the defendant's responsibility. Other employees in Relime had the responsibility for undertaking due diligence and compliance checks. Who undertook them? What were they? What did they find? All of that is relevant to any continuing representation which is alleged against my client. Then there are alleged to be further material misrepresentations. Well, they either relate to King Barnes, so it's variations on the theme, or there are allegations of red flags. We were silent. Well, silence can't constitute a representation. Paragraph 72, we turn to the law, and Your Honour can be confident that we've approached it in the right way, because for present purposes, it must be assumed that the claimant, and to the extent it seeks to be joined Relic, are able or would be able to establish the pleaded facts. But even doing that, any claim is unsustainable on three grounds: intention, inducement, and materiality. And what we've set out in each of these is the passage in Chitty, which deals with each of those elements. I won't weary the court with going into it. What we've done is set it out in paragraph 74 with regard to intention. Paragraph 75 distills what is said in the remainder of paragraph 9037 in Chitty, which identifies three types of representees. And we've taken each one serially and explained why the intention cannot apply to any of the types on the facts of this case. So when you go back to the test, the person seeking relief must be able to demonstrate that he is a representee for the person or persons who in law come within the category of representees are alone entitled to a remedy, claimant must show it was intended that he should act on the representation. The plain fact is Relic can't do that. Inducement, representation, the representee unaware of the representation, paragraph 79 of the skeleton argument. Again, the general principle on which we are relying in Chitty is set out from paragraph 9041 in paragraph 79. Paragraph 80, Mr. Khan imparted nothing directly to Relic. So either Relic was unaware, in which case it can't have acted as an inducement for the purposes of the representation, or it was repeated to Relic as part of the due diligence and compliance checks. And at the end of paragraph 80, top of page G718, we look at what the case is if it was the former, we look at what the case is if it was the latter, and in neither regard does Relic bring itself within the appropriate category to establish that it was induced. Then materiality. A statement must be material in the sense that it was likely to induce the contract. And as part of that, Chitty at paragraph 9049 refers to an entitlement to rely. And paragraph 83, no entitlement to rely. Then dealing specifically with fraudulent misrepresentation, because this is a case which Relic seeks to bring in deceit, we set out the general principle. It doesn't take matters very far at 9055, paragraph 84 of the skeleton. The contract in question is the referral agreement. This is paragraph 85. That contract was between Relic and King Barnes. Mr. Khan was not acting as agent or otherwise on behalf of King Barnes when he said that King Barnes had been referred by Imani Wealth. So any representation had not been made by the other contracting party. And again, we bring in the reasons already discussed about the lack of inducement. Then paragraph 9055 continues in Chitty that it's for the representee affirmatively to prove the fraud, and the burden is no light one. And then we've referred to a footnote 286, and it may be helpful if I give the court the specific page reference to that footnote. It's page 1017. And at 1017, there's further discussion of how the burden is to be pleaded. But the burden needs to be, essentially, it's the point that if you are making an allegation of fraud, albeit that the test is still, the burden is still, the standard is still the civil standard of proof, then there must be a greater level of cogency in advancing a case in fraud. And we relate that back to this case. There is no cogency in a case in fraud, deceit being raised by a Relic against the defendant. Now we keep our powder dry in relation to Relime, but the focus is on Relic. And we conclude matters there that for the courts, for the completeness of the court's knowledge, a recent case summarising the principles is referred to in paragraph 89, but it's quite clear that Mr. Justice Foxton in that case had Chitty in mind, because he refers to it expressly in one of the relevant paragraphs. And I've gone back to Chitty. I hope I've set it out appropriately, and it would just be unnecessarily burdensome to go through it all over again. So our conclusion on deceit and misrepresentation is set out in paragraph 92. Paragraphs 93 and 94 we can skip over because breach of contract isn't relevant to Relic. Negligence, this is depends on reasonable foreseeability, and whether it is, and there are two closely related limbs, which we've taken again from the very recent case, Court of Appeal decision in England and Wales, McLean and others against Thornhill. The two limbs in relation to reasonable foreseeability are, one, whether it was reasonable in the factual circumstances and context for reliance to be placed on what was said without independent inquiry, and secondly, whether it was reasonably foreseeable by the representor that the party placing reliance on what was said would do so, i.e. would rely on it without independent inquiry. Well, again, when one stands back from this, neither limb of that test can be satisfied on the facts of this case, because taking the first limb of reasonability of reliance without independent inquiry, we say it wasn't reasonable for anyone to rely on what Mr. Khan said without independent inquiry. And indeed, there was an independent inquiry, which takes us back to the complete absence of any pleaded case and specificity in relation to what happened. And that is critically important because it breaks the chain of causation. It means that it wasn't reasonable for Relic, in this instance, to rely on anything that was said by Mr. Khan, because there was intervening due diligence and compliance checks. Secondly, it was not reasonably foreseeable by Mr. Khan that Relic would do so, because having passed everything over to other people in Relime for the express purpose of carrying out due diligence and compliance checks, what this case now seeks to do is set all of those elaborate checks necessary for regulatory purposes at naught and rely on something that wasn't even said by my client to Relic. So on that basis, we go back, having gone through that, to Articles 17 and 18 of the Law of Obligations, and we say that the defendant did not owe a duty of care, and our conclusion on negligence is that, again, that plea is bound to fail. Now, Your Honour, we don't need to deal with loss and damage for present purposes. The conclusion in this regard, paragraph 100, is that Relic has no case. It's neither desirable to add Relic, nor is there any issue making it desirable to add Relic, and neither limb of Rule 20.7 is satisfied on this pleaded case. Well, I'll pause there because we are, I think, dealing with the joinder matters before other matters, but unless I can assist the court further, that is what I say in opposition to this joinder application.
Thank you very much. Mr. Doherty.
Yes, Your Honour. I thought I'd just ask you at the outset, is there anything specifically that you would be assisted with, and I can focus on that? Otherwise, I'm happy to respond to the various different points raised by my own friend.
Well, you take your own course for the moment, and I'll probably interrupt at various stages, but...
Yes, thank you. Dealing with the points, I think, broadly in the order that they arose. Timing, we've been criticised for deliberately harassing the defendant. So I find it slightly surprising to hear that sort of submission levied. From the claimant's perspective, it has heeded the judge's quite sensible suggestion. At the last hearing, the parties engaged constructively and proportionately, and we have tried to do that. But I know that my learned friend is probably aware that a joinder application like this is supposed to be accompanied by proposed draft particulars of claim. That's RDC 20.18. In order to provide those, I would have hoped it would be obvious to my learned friend in the course that I actually needed to sit down and write them first, which of course Your Honour will remember is why we set the deadline that we did at the last hearing. And so the particular claim was ready in line with the deadline I had proposed, and the amended particulars of claim was therefore provided at the first possible opportunity, in effect at the same time. I don't think there can be any realistic suggestion that this is somehow harassment. We didn't provide them with the amended particulars of claim the day before the defence was due or anything close to that. And so I don't really know what the point being made there is. As to the allegation of tacking on, having given Your Honour the history of that, it probably wouldn't come as a huge surprise that when the pleadings were being drafted, it was, of course, in the knowledge that an application for joinder was going to be made. So when it was drafted, the original particulars of claim was put in a way that covered the same common factual circumstances relevant to both parties. And so the fact that the red line simply adds and or relic is part of that procedural history, because as should be obvious from the way in which the joinder case is put, the duties are said to arise from common issues of fact. The addition of the parties is the only thing that's changing on joinder, and the particular claim was drafted in that way deliberately. It's not an afterthought. It's to make clear that those are in fact common issues. And again, turning to the various different pleading points, it's notable that my learned friend didn't actually go to specific instances in the amended particulars of claim that he takes issue with. In my submission, it's a relatively lengthy pleading, setting out the details that need to be set out. My learned friend hasn't gone to those to say, well, here's what's not pleaded. It covers all of the facts and circumstances that are said to give rise to the relevant duties. It pleads out the relevant contractual terms. We've got explanations of the interactions between Relimi and Relic. Para 15, we've got the various different representations that are being relied on at 17, 30, and 37. We have references to Bank of Singapore being a long-standing referral of the Reli Group more broadly. We have references to the draft letters produced on behalf of Relic by the defendant. We have references to the fact that he knew that those representations would be relied upon by both Relimi and Relic. So it's difficult to see which particular aspects of the pleading that the defendant now takes issues with. It seems that the criticism, if there is one, is that we haven't predicted each and every point that the defendant is going to take, and therefore provided the detail the defendant wants on those. But if the defendant has those sorts of pleading points that it wants to take, what it could have done was plead a defence and open the claimant up to that criticism, which could then be dealt with in more detail if that's what was relevant in reply. But these provisions about due diligence are a good example of that. The defendant's now saying, well, you haven't said what the checks were, you haven't said who did them, you haven't said when they were done, and so on. Well, the simple reason for that is that because it's not a known issue, it's only become a known issue as a consequence of the stance in my learned friend's skeleton argument. In my submission, it's in truth probably more a matter for evidence and submission than it is for pleading. But if that's something that the defendant wants to put in issue, then it could plead a defence and do that. And perhaps we can have a reply which sets out what the checks were, and then those issues can be investigated at trial. But the position seems to be that the defendant is never going to be satisfied with how the case is put, and so is invariably using what we would suggest is an inappropriate mechanism of the court, i.e. trying to effectively strike out a claim for relatively minor pleading points, which is not the appropriate course. My learned friend dealt with a number of points on the employment letter. Effectively, their case is that the employment letter is not a contractual document. The only contractual document is the employment contract. Respectfully, we do say that's a slightly odd submission, because there's no reason why in law that should be the case. All sorts of contracts are comprised of multiple documents and incorporate multiple documents. It's equally common for contracts to specify what should happen in the event of a conflict of terms. And even if they don't, the mere existence of a conflict of terms doesn't render one contract void and another effective. The nub of the defendant's submission seems to be that it requires the words proposes to engage to do an awful lot of work to render the employment letter of no contractual effect. But with the greatest respect, that submission isn't realistic. A number of reasons. First of all, it's obvious that a contract can bind a party to undertake a step in the future, as opposed to simply requiring them to do it immediately. So a contract saying you will be employed is no different to an employment contract that's executed before a formal start date, for example. So by my learned friend's contention, if you have a contractual obligation that you will pay some money at some point in the future, that would have no contractual effect because it's only a proposal. And the second is really simply that the employment letter is clear in its own terms, that it's a contract. If your Honour wishes to look at it, for example, page 408, it's the same in both iterations of the contract. But you don't really need to look much beyond the first 6 words, which says the purpose of this letter brackets the agreement. And sorry, if you're on, can let me know when you have that. My system is going quite slowly. I don't know if you have the same issue. At 409, clause 3 says this agreement will be effective from November 1st, 2018. Clause 3D at page 410 also talks about termination of this agreement and the basis upon which it can be terminated. 411, clause 6, which Your Honour has looked at already, explains the interaction of the letter and the employment contract. And so one of the contractual effects of the letter is that it contains a binding obligation to then execute the employment contract and provides for circumstances in which the terms of the 2 agreements, i.e. it envisages that they are both contractual, should be dealt with. And that sort of provision is impossible to make sense of if it's not intended to be an agreement. And the document itself is replete with terms that make clear that it's a contract, including the usual terms one might expect on notice, severability, modification waiver, those sorts of things. And very simply, page 413, we have the defendant's signature below the words accepted and agreed. So the suggestion that this is not a contractual document, albeit it's probably an issue for another day anyway, but it's not a realistic submission. And what the defendant then tries to do, I think, is to justify its stance by saying, well, what are we to make of the Hong Kong jurisdiction clause in that case? I think that there's a pretty simple answer to that, which is both parties in these proceedings have asserted that the DIFC court has jurisdiction, and nobody has dissented from that. Even faced with a jurisdictional challenge, of course, which we don't have here, the existence of a jurisdiction clause or even an exclusive jurisdiction clause still does not preclude the DIFC court from assuming jurisdiction anyway. That's clear from the graphy line of cases. And there are all sorts of other ways that one can get to that result, so arguments like forum non-conveniens and so on. But the simple fact is that both parties accept the jurisdiction of the DIFC courts because it's clear that the substantive disputes in both the claim and the counterclaim arise under matters of DIFC law. So that's the law of obligations and the employment law. But even if one puts all of that to one side, it's still very difficult to understand where the argument gets the defendant on this application, because it's common ground, whatever way you read the terms of the Hong Kong jurisdiction clause, or how that you should want to construe that. If the only contract is between the defendant and really me, it is not in any event a jurisdiction clause that can bind Relic, which is what we're considering on this application. So Relic is not a party to this contract. It's not a party to any jurisdiction clause. And it's therefore difficult to understand how the defendant can rely on the employment letter, which on its own case isn't even contractual full stop, how that could then be relied upon to say that there is a binding jurisdiction agreement that says that any dispute raised by Relic should be before the Hong Kong courts. And indeed, I think, as Your Honour was alluding to earlier, if there's any force in the defendant's argument, there is a real risk that its hidden counterclaim would need to be submitted to the Hong Kong courts. And I gather that's probably not the result that he wants. Your Honour raised another point about commission, and this was in the context of whether the employment contract is the only contract that the defendant relies upon, and he says that it is. That does make a substantive difference to his rights. And I'll explain this as briefly as I can. If you start at page 102, and if Your Honour could let me know when you've got that reference.
Yes.
This is the employment contract. So on the defendant's case, this is the only contractual document there is. And you see in the parties, one, RED International Middle East Limited, a company incorporated in, etc. And then you see at the end the defined term, the company, capital C.
Yeah.
If you go forward to page 114,
Yes.
this is the Exhibit B to the employment contract, which says that the following earned commissions will be based upon the net revenue received by the capital C company.
Yes.
Now, as a matter of construction, that is different than if one goes to page 89, which is the employment letter.
Yeah.
And just before I get into the substantive submission, it is also notable that this employment letter, this one is dated 1st of October 2021. So this is while he's already an employee.
Yeah.
And the reason that's, of course, potentially relevant is that it's not that he's just in the process of joining the company and he's being sent an offer of employment and the letter is just a proposal in that sense. This is being sent to him while he's already an existing employee of the company. But the relevance here is in the first substantive paragraph, the company. So if you look 3 lines up from the end of that paragraph,
Yeah.
the company is given a collective definition.
Yes.
And so when you go forward to page 98, which is the commission structure exhibited to the employment letter, it changes the meaning.
It's all back to front though, isn't it? The first paragraph anyway. Because it refers to a brokerage company, Reline, and a marketing support company in the Cayman Islands. So it's got that inside out. It's a shambles.
I think that the intention is that if you looked at Exhibit A, page 95, for example, it's the schedule which tells you who the contracting entity is. But we're not necessarily interested on this issue on who the contracting party is, but the question is, how do you interpret what the entitlement is?
Yeah,
and so if you look at the employment letter, it suggests that the entitlement would be to net revenues by the company as a whole. And that's why the defendant has been paid. So it is now his case that his only contract is the employment contract. What he'll find is that he's entitled to about 23% of what he thinks he's entitled to, and there may well be issues with historic overpayments and things like that.
Yes, I understand that. That was the point I asked. That choice.
So that was really just to provide that explanation of why this argument doesn't really work, we say. Jurisdiction, I think I've addressed Your Honour on already. Unless you have any specific questions about jurisdiction, I don't intend to go back to it. Fiduciary duties, it seemed as though Your Honour had the point that ultimately the question of whether or not there is a fiduciary duty is factual. You might recall in the last hearing we had back in April, I referred Your Honour to two cases, JD Weatherspoon and Harris. So these are relatively well-known authorities on the application of strikeout principles. But just to remind you of those, so this is an extract from the Weatherspoon case of 14. It says, I do not consider that the summary judgment applications are in principle appropriate. They're based on a particular interpretation of facts which are in dispute and not unusually in the case of allegations of fraud and dishonesty, on the inferences to be drawn from established fact. And it goes on to say, in the light of substantial factual and documentary evidence in the present case and the matters which are in dispute, this is, to my mind, precisely the type of mini-trial of disputed facts or the documents for which summary judgment procedure is inappropriate. So the two obvious points are, first, that the court's presented with substantial documentary evidence about matters which are in dispute, and that we're in precisely the territory where those cannot be dealt with on an interlocutory basis. But the second point is that's particularly acute in cases like this, where we've got allegations of dishonesty and fraud. And the second case, very briefly, was Equitable Life Assurance and Ernst & Young, which again points out there, and I quote, there is a danger of injustice in trying to try such cases summarily on the documents and without disclosure and oral evidence tested by cross-examination. It should not be done unless the court can be confident that all the relevant facts have already been satisfactorily investigated. The power of summary disposal is not intended for cases which need to be investigated at trial. And that presents an obvious difficulty for the defendant on this application of judiciary duties, of course. The provisions of the law of obligations itself say that it is a matter of fact. So it's Article 1583. In all other situations, it is a question of fact whether in all the circumstances of the case a person is a fiduciary. And what my learned friend says here is, well, you're not in one of the established categories, such as an employee under the law of obligations, and so you have to do something to bring yourself within an exceptional category. Well, that's not what the law of obligation says. What the law of obligation says is, here are examples of where a fiduciary relationship can exist. Although it should be noted that the law of obligations does not say a fiduciary duty always exists in those circumstances. They're just given as examples of when it can. All that the law of obligation says is this is a question of fact, and you have to look at it in all of the circumstances of the case. And the same point can be made not only of the existence of the duty, but also the scope of the duty. So what Article 159 says is that a fiduciary's obligation of loyalty comprises such of the duties as set out in Schedule 3 as are appropriate in all the circumstances of the relationship between the fiduciary and his principal. So one looks at in the round, in all of the circumstances of a particular case, does the relationship exist? What is the scope of that duty? And whether on the facts the duty has been breached. And again, as a statement of what I would hope would be basic principle, I've referred Your Honour to extracts from Snell's Equity. It's at page 824 of the bundle. And it's at 7-12. It says the scope of fiduciary duties is moulded according to the nature of the relationship and the facts of the case. However, application of fiduciary doctrine is not an unprincipled exercise in judicial discretion. Rather, it requires a meticulous examination of the facts of each case in order to determine what non-fiduciary duties are owed, so as to be able to determine the effect the fiduciary principles will have in the case. It goes on to say a fiduciary relationship cannot be superimposed upon the contract in such a way as to alter the operation. But the next paragraph again makes more of the same points. Careful analysis of both fiduciary and non-fiduciary duties is crucial. Before going on to refer to another quote saying, for this reason, there is no class of case in which one ought more carefully to bear in mind the facts of the case than cases to which fiduciary, which relate to fiduciary and confidential relations. So it is of the utmost importance in cases alleging breach of fiduciary duty that one actually looks at the facts of the case. And on that basis, we're dealing with a situation where we fall squarely outside summary disposal territory. And the only question is the court going to look at the facts and circumstances in relation to Relly-Me? Are those the same as in relation to Relic? And if so, is it desirable that the issues should be tried together? On deceit and misrepresentation, again, it seems as though a number of pleading points are taken without actually referring to what the particular issue with the pleadings are. What the pleading says is that there are 3 specifically pleaded representations. When the particular claim was drafted, it set out those representations in quotes. They're paragraphs 17, 30, and 37 of the particulars of claim. One of the issues that appears to be taken is, well, the representations were made to other Relly-Me employees. But I think really that's a question of not only fact insofar as what did the defendant expect those representations would be used for and would they be passed on, but also there are potentially legal issues. So, for example, the defendant accepts paragraph 75 of my learned friend's skeleton that misrepresentation can include cases where there is a representation that is expected to be passed on. And the statements that are engaged here are in my submission, clear. They're understood by the defendant. They know what's being alleged. It's that the defendant made statements concerning the source of Kingsbarn's introduction, i.e. it was by Imani Wealth. He says that was by mistake, but whether or not that's a mistake or whether that was dishonest is going to be a factual issue for trial. And he made those statements knowing that what was going to be the end product of this is a referral agreement executed by Relic and Kingsbarns. And we know that he knows that because he procured the signing of that document. He's procured the signing of other referral agreements in the past. We also have more direct representations being made, of course, because the pleaded representations include the draft letters, which were to go to the insurer. So those were the letters saying Mr. and Mrs. X have been referred by Imani Wealth. They've known Imani Wealth for 5 years as their financial advisor. So those are letters that he has drafted, knowing that they're going to be issued by Relic to the insurer. And we know that he knows that again because we've got all of the other evidence of him drafting those letters in the past. So the issues are, in my submission, clear on the pleadings. When you see what the issues are, it is obvious in my submission that they're issues of fact. The residual point that now appears to be raised by my learned friend is this question of due diligence, and he says that because due diligence was carried out, it makes the case unarguable. There's simply no authority whatsoever anywhere which says that a company, in carrying out standard due diligence checks, negates a potential defendant's fraud. Commercial parties to contracts conduct due diligence checks on contractual counterparties as a matter of course. For example, they need to make sure that the companies they're dealing with exist, that they're not, facilitating money laundering or sanctions breaches, all things of all sorts. But if my learned friend is correct in that submission that it's unarguable, a malign actor would be at liberty to make whatever false representations they want about a particular transaction, because they'd never be liable for it so long as there are basic due diligence checks carried out. And my learned friend's submission beyond that assumes the due diligence checks had any bearing on the operative part of the fraud, which is these were referred by a trusted professional relationship, i.e. Imani Wealth, that these individuals have been represented by these legitimate financial advisors for a period of 5 years. And that's not what due diligence checks cover. They cover things like, is this a genuine business? Let's get hold of its corporate documents. I mean, if anyone wants to look at it, we have the evidence already. It's page 123 of the bundle. And if you want to let me know when you've got that page reference.
I have it.
So a couple of points here. One, we've got a list of basic corporate documents: certificate of incorporation, partner list, MOA, trade license. What's also of potential significance is that these are being sent by Mr. Khan, the defendant, who is getting involved in the due diligence process. But what we're not looking at here is someone chasing up to check whether what Mr. Khan said about Imani Wealth was true or not. That's not what the due diligence checks are. And so the idea that the due diligence supersedes reliance on the statement and entering into the referral agreement is not only wrong, we say, on the facts, but it's clearly not a point that makes a case unarguable. And as I say, the residual points that my learned friend relied upon, so that it wasn't intended or expected that the representation made to Relly Me would be passed on, that there are questions of intention and inducement, etc. Again, these are all questions for trial. They're all issues of fact. But on their face, we have enough to see that there is grounding of a case here, because the defendant was involved into the execution of the agreement. He was involved in email chains which relate to due diligence. He was responsible for drafting letters to the insurance carrier. It is obvious, and it will be argued at trial, that it would have been obvious to the defendant that he knew Relic was the party to whom his representations were ultimately being made and relied upon. And the giveaway for the misconceived nature of my learned friend's argument is when he says at paragraph 86 of his skeleton argument that the claimant doesn't come close to discharging the burden of proof, somewhat misunderstands the point. The pleading is there to set out the essential facts of the case. By the time you come to prove your case, you do it with witness evidence and you do it with documentary evidence at trial. The defendant, of course, is entirely and perfectly entitled to take whatever points it wants in its defence. But whether or not the deceit claim is a good one is something that necessitates a trial and investigation of facts. And much the same observations, for the avoidance of doubt, can be made about the claim in negligence. All we really have in my learned friend's skeleton argument in paragraph 97 is a list of bare assertions, such as the requirement for foreseeability is not satisfied. There's no sufficiently proximate relationship. None of that's addressed in any detail. So it's quite difficult to understand on what basis it's said that the arguments are legally misconceived. And with respect, those are bare submissions that one could expect to find in any negligence trial. but they're not propositions of law that render a claim unarguable. A finding of existence of duty of care, much like fiduciary duty, requires an investigation of the facts and circumstances to determine, does the duty exist, what's the scope of the duty, was it breached? Your Honour, I'll just briefly check my instructing solicitors, but I think that in a nutshell replies to the points relied upon by my learned friend. If it, as I say, if there's anything else that I can assist you with, I would be more than happy to. Your Honour, I think that is it.
Thank you.
Your Honour, my learned friend has raised some new points. In particular, he's referred to new authority, in which I should have the right to come back on in
Yes.
ordinary course, and I hope I may.
Yes.
Thank you, Your Honour. Well, the first point is my learned friend has signally not addressed anything on Rule 17.43. And indeed, he said that as regards what the due diligence and compliance checks were, then it could be set out in the reply what those checks were. It is fundamental that, and it's in the rules of the DIFC courts, that new cases should not be raised in the reply. And Rule 17.43 is clear. The time for setting out the case is the statement of case. And this brings me back to the additional cases my learned friend has referred to, in particular Weatherspoon and further case, I think it was Johnson Arabia, I'm not too sure, it doesn't matter which. What my learned friend is essentially seeking is to engage in McCorberism. He's saying it will all come out in the wash. We'll find something in the reply. We'll find something in the facts. It all has to be opened at trial. The point in our submission is very straightforward, Your Honour. If the pleaded case, if the pleaded facts do not establish a case, it is not desirable to join a party. And that does not rely on factual issues. It relies on the pleaded case. A couple of further very small points. My learned friend refers to letters that my client drafted. He's taken you to them, but Your Honour asked who was Mr. Sean Parker. Mr. Sean Parker is another employee within Reline who approved and passed on those letters. They may have been drafted by my client, but they were passed on through the process of others in Reline. And my learned friend says in relation to paragraphs 86, and I think he tries to make the same point in relation to the pleadings of negligence, but paragraph 86 of my skeleton argument, where he says that discharging the burden of proof is a matter for trial. So it is, but that is not what I said in paragraph 86. What I said was that neither the claimant nor Relic, the party relevant for present purposes, has pleaded anything that might remotely come close to discharging the burden of proof. The case must be set out in the pleading, and that is the gravamen of our objection to this application to join.
Sorry, may I come back on 2 sentences to clarify a point?
Yes, please do.
Yes. This point about due diligence, that is the defendant's case. The defendants set out in their skeleton for the first time the argument that due diligence negates reliance on the representation. That's not the claimant's case. The claimant's case is that it relied on the representation. So if it is a point to be pleaded out, it's a point to be pleaded out by the defendant. It's for the party asserting matters of fact and law to put their case. So that's why it doesn't appear in the pleading. That's all I need to say.
I just want to ask one question, Mr. Doherty, which relates to the jurisdiction clause in the letter agreement. You may want to turn to that at D89 or thereabouts.
Yes.
If we look simply at first clause 6, that deals with a conflict between the provisions of the agreement in the letter and the DIFC employment contract, properly so called.
Mm-hmm.
No one, I think, is suggesting that there is any such conflict, except perhaps in relation to jurisdiction. We then go to the jurisdiction clause 12. And this that doesn't have a form of words which says that any dispute arising out of or in connection with, or, there are many forms of words that are used in these clauses that cover torts and goodness knows what. That this deals specifically with validity, construction and performance of the agreement, which is governed by the laws of Hong Kong. And then it's the courts of the Hong Kong Special Administrative Region shall have exclusive jurisdiction of any lawsuit arising from or relating to your employment with or termination from the company, which is then defined as, I think you showed me, the group in the first paragraph.
Mm-hmm.
So the question which arises first is, do you rely on this employment letter and a failure to perform under the employment letter? Because if you do, it appears to me you have to go to Hong Kong. If you don't rely on it, are you entitled to rely on it not as a contract, but in the context of the background for the fiduciary obligations which you say are owed?
I think the simple answer is that we don't rely on there being a breach of contract, because it's common ground for the purposes of this application that Relic isn't bound contractually. So no, we're not relying on the terms. The relevance, and another example, I apologize, I ought to have brought you there earlier. It's simply in relation to what did the defendant expect he was going to be asked to do in carrying out his employment responsibilities to Relly Me. And is he right when he says, I had no idea that this had anything to do with Relic? Or are we right in saying that he knew he was carrying out responsibilities to Relic? I suspect that the facts and circumstances that go to that issue are probably going to be more persuasive when it comes to what actually happened in the ordinary course of things than what the contractual documents say. The point that we highlighted was simply to say that there are contractual terms which ought to have given him the expectation that he would be asked to perform tasks which require him to work with or on behalf of or alongside other group entities. And other examples of that, if you go to page 107, this is the employment contract rather than the letter, which provide, amongst other things, that you can have your contract terminated. So it's 13.5.4 if you act in any way which may, in the reasonable opinion of the company, brings the company or any group company into disrepute.
And is there a jurisdiction clause in the employment contract?
It's the IFC clause 28.
Just give me the page number.
It's 111.
Thank you.
I mean, I don't know how much it assists as far as it relates to the defendant and really me as the contracting parties, both of whom have raised strikeout applications. There's probably a question of submission to jurisdiction by this point in time anyway.
Well, I think there is, but the point I was driving at and trying to grapple with was the conflict that on the face of it exists between clause 28 of this contract and clause 12 of the letter of agreement in relation to jurisdiction, where the jurisdiction clause in the letter agreement refers to employment in general by the company, which includes each member of the group. So there is, on the face of it, an apparent conflict.
Sorry, I can actually probably provide a more specific answer to that as well, because the beginning of the employment letter also says the terms upon which you are employed by one or more of the companies. And what Exhibit A to the letter does is it actually specifies that you're employed by one. You're not employed by multiple. So there's it seems to me there are two issues. There's one is, who are the contracting parties? The question of jurisdiction, to which the answer is really me and the defendant. And then there is a question of how do you then construe terms, for example, relating to entitlements. That's when the potential relevance of broader companies can come into play, because it might have an impact on how you construe substantive rights. I hope that makes sense.
Well, I had always taken the view that so far as the employment is concerned, we have a specific contract here between the Middle East company and Imran Khan, which has its own jurisdiction clause. And regardless, therefore, of the terms of the employment letter, that would actually prevail. Now, Mr. Patchett-Joyce says the earlier letter is not a contractual document at all, so he doesn't have a problem with that. It's only you who has a problem insofar as you rely upon it. And the point I was making to you is this, that it seems to me that there is a potential problem if you want to rely upon that as a contractual document. And the question then arises whether Mr. Patchett-Joyce is going to apply for a stay here in favour of Hong Kong. Now, he's got a problem by that because he doesn't want to rely on it. So where do we get to in all of this? The court obviously has to take a sensible view. It's got jurisdiction on the face of the letter, the employment contract, and will exercise that jurisdiction in the absence of anybody telling it that it shouldn't. That's, I think, where we get to on this, so that for practical purposes, I don't have to pay any attention to the Hong Kong jurisdiction clause unless someone is asking me to.
From my perspective, I think that's correct, Your Honour. I don't think I have anything to add to that.
Right.
Well,
what you say, however, in your skeleton at paragraph 13b is undoubtedly different from what appears in paragraph 5 of your amended particulars. In paragraph 13b of your skeleton, you say Relic has no claim against D in contract because the only contractual relationship is between D and Reline. But actually, in paragraph 5, you're saying that the contract consists of two documents. which includes the letter agreement, which is entered into by Relic. Now, it seems to me that you can't have your cake and eat it. I think Mr. Patrick Joyce said can't run with the. He said with the fox and hunt with the hounds. I think it's the hare and the hounds, properly so called, in the little aphorism, isn't it? But never mind.
It seems to adopt the different animal, my lord.
The question, I think, is whether, in fact, you run yourself into problems by relying upon the letter agreement as a contract. Or whether, in fact, as we've just discussed, it matters not at all in the absence of anybody taking the point and seeking to stay some part of this claim to go off to Hong Kong. Which is why I ran through the whole future possibilities with Mr. Patrick Joyce and saying that, you know, if I was to send that off to Hong Kong and you finished up with 2 lots of proceedings, in the end, one party or the other would be saying, well, this is just silly. We're having the same basic debate going on in 2 jurisdictions, albeit between 2 parties. And you rightly point out that Mr. Patrick Joyce wants his commission based on the net receipts of the group. So it doesn't do anybody any favours if I have to do that.
No, quite right, Your Honour. I simply point out the pleading doesn't say that the employment letter is with Relic. I think it was to reflect the fact that the letterhead, if you look at it in 89, refers to REB International Hong Kong Limited. And it refers to the group company, so it was more of a factual description than it is attempting to describe the legal effect. The fact that the pleaded case doesn't rely on the existence of a contract between Relic and the defendant should, I hope, be clear from the red line amendments in the proposed particulars of claim, because there is no amendment to the contractual claim. Of course, if we were asserting the existence of a contractual relationship, it would follow that we would say that there was a breach of the terms of the employment letter as it relates to Relic, but we're not saying that.
So, in fact, then, you would need to be saying, well, you are telling me, and it may be you need to amend, that 5A, in referring to an employment letter with RELI Group, in fact, you are saying that this is a contractually effective between him and Relime, as opposed to Relic. Is that right?
Yes, so there's nowhere on the face of the pleaded claim that asserts a contractual relationship as between Relic and the defendant.
Right.
The breach of contract section in paragraph 62 asserts the defendant breached his contractual obligations to Relly Me in the following respects.
Yes.
And then it refers to the various provisions of the employment letter and the employment contract that are engaged. And the reason that the employment letter engages a contract as between the defendant and Relly Me, the Middle Eastern entity, is because appendix, I think it's called Exhibit A, actually, Exhibit A to that agreement tells us that that's who the contracting party is in this case. So it's taking what is, in effect, one assumes a standard form letter issued by the group and saying you will be employed by one or more, and then Exhibit A tells you who the one or more is. And that's where the contractual relationship arising from the letter arises.
If paragraph 5 was to read, on 1st November 2018, the defendant commenced his employment with Relime by entering into 2 agreements, A, an employment letter with Relime as part of the Relly Group. That would make it clear that you weren't saying that there was a contract with Relic.
Yes.
Right. I think that would be a helpful thing to do in the context. I'm going to cut short much of this debate because it seems to me that
is there anything you would wish to hear from me on in relation to what has just passed between you, the court and Mr. Doherty?
only if you think you've got something helpful to say, Mr. Patrick Joyce.
Well, Your Honour asked learned friend twice if the employment letter is not a contract, whether he's entitled to rely on it as background for the fiduciary obligations. And
yes,
as I listened, my learned friend didn't provide an answer to that. But
no.
In relation to the jurisdiction, this underpins the whole differentiation between relime and relic. And
I understand that.
So with respect, the rewriting of paragraph 5A, which the court is indicating to my learned friend, won't do, because how does the employment letter become contractual? Because as we said in paragraph 37 of the skeleton argument, the employment letter begins with the phrase proposes to engage, and Exhibit A, which my learned friend has just relied upon, begins with the words upon your hire. So I'm afraid I just don't see how my learned friend brings this in, and then on the coattails of that enables Relic to pursue a case in the DIFC, and it's Relic only which we are objecting to, because, as I've indicated to the court, we have our counterclaim, which is based on the course of dealing established between the parties, those parties being my client and his employer. That's what I would say in response.
Yes, thank you. Well, I understand that. I say I think I'm going to cut short the debate because it appears to me that there's a need for some repleading here before I can allow a joint to take place. Although it seems to me, without committing myself, that such joinder will be likely to take place in the near future. I'll ask Mr. Doherty when I've explained what I think needs to be done about how much time he needs. I think there are two areas where there is a need for further pleading. First of all, I think Mr. Patrick Joyce is right in saying that there are inadequate pleas in relation to the receipt of the misrepresentation by Relic from Relime. Whilst it seems to me highly likely that all that what was said was passed on from Relime to Relic, there is no pleaded. There are no pleas that so state, and likewise there's no particularity in relation to the question of reliance or inducement. And Mr. Patrick Joyce is right to point to RDC 1743 in order to say that there must be particularity in relation to pleas of misrepresentation and inducement stroke reliance, including the people concerned. That is all the more the case where an element of fraud is being alleged. As a matter of law, due diligence is no defense to fraud. A fraudster can't say, you were stupid to believe me, you should have carried out your own checks, or you carried out the checks inadequately. Of course, it's open to him to say you weren't deceived at all, but that's a different matter. So the pleas of misrepresentation, so far as they concern Relic, must be properly particularised if they are to stand. The second question is the question of fiduciary duty. It seemed to me, the more I heard from Mr. Doherty, which confirmed my immediate reaction, was that there is enough here to raise the argument of a fiduciary duty owed to Relic, but that the matters upon which he relied in his oral address were not matters that were specifically pleaded. I'm looking really at paragraph 16 of the current draft. And thinking of the letters that were referred to by Mr. Doherty in relation to recommending referral agreements and drafts of them and so on and so forth, as between Relic and third parties. I don't think, unless I've missed it somewhere, that there's any express reference to that. But the essence of the fiduciary relationship depends upon the nature of the relationship between Relic and Relime and how the two operated together. And I've seen enough on the witness statements to know that there's sufficient there, in fact, for this argument to be run, but it doesn't seem to me that it's pleaded. And therefore, particulars of those matters which are relied on in support of the allegation of a fiduciary duty need to be set out. So that, I think, is where we get to. And Mr. Doherty, you need to tell me how much time you need to put your house in order on that basis. And I say this to Mr. Patrick Joyce so that he is well aware, in case he hadn't already picked it up, that I think that's subject to proper particularisation. This is plainly a case where there should be joinder, where it would be highly desirable for these matters to be dealt with, because in the end it is going to be much the same area of fact which is going to be explored at the hearing in relation to both Relic and Relime. And it makes obvious sense from the court's perspective for Relic to be in there at the same time, whether or not you think you can make good your counterclaim for commission based on net receipts of the group without Relic's presence. But there it is. If at the end of the day, Mr. Patrick Joyce, you and your client wish to be difficult about this and apply for a stay because you think the claim as pleaded, then it raises matters that ought to go to Hong Kong, then that's a matter for you. You'll have to decide. I want this bit to go to Hong Kong, and we'll then have to grapple with any question of separation of one from the two. But it doesn't make any sense to do that. The difficulty arises in the very area we've discussed, which is, though there's not reliance on the contract as contract, there will be reliance on the existence of that document as forming part of the relationship, the matrix, whatever you want to put it, against which any court would consider whether a fiduciary duty was or was not to be imposed. But it's only one part of the picture. The other part, as Ms. Doherty says, being actually what happened on the ground, which is going to be a more reliable indication, particularly as these documents were drafted with a view to compliance, no doubt, with licensing law for brokers and so on in the DIFC, and still managed to get it back to front in the first paragraph of the letter of employment. Mr. Doherty, how long do you need?
I don't think it would take very long at all. I don't think that there's. It doesn't. It sounds as though it's going to be a matter of paragraphs. The one thing I am slightly hesitant or concerned about is whether we end up batting around the same issue and coming back to the same place. And I sort of
that's why That's why I've just said what I've said to Mr. Patrick Joyce, because it seems to me that almost inevitably one's going to finish up with a case that where joinder is appropriate, certainly on the fiduciary duty element.
Yes.
Because I've seen enough in the witness statements to know how the system works, and simply think that ought to be. I can well understand how it may well be possible and even likely, but I don't have any facts at all pleaded in relation to receipt of the representations by anyone on behalf of Relic as such. And at the end of the day, you know, if this watch is going to be taken in relation to Alliance, Mr. Patrick Joyce may want to cross-examine witnesses from Relic to find out whether they did rely on it, and so on and so forth. I think that's unavoidable. Yes, so joinder, as I said, I think is highly likely on the basis of fiduciary duty, but I can't really say in relation to the misrepresentation, please, whether there's how much there is in that without some proper particularization. That's the whole purpose of the rule.
Yes, I suppose what I was potentially flagging was a query, I suppose, about efficiency and way to get to a point where the defendant is happy and not bringing a third strikeout application. There are, of course, provisions in Part 19, is what I would allude to as being a route to the defendant getting what it wants out of this, which is if one party is not happy with another party's specificity in its pleaded case, the ordinary course would be a Part 19 request to produce further information.
Well, I mean, I entirely understand that, as long as you've pleaded out a case in the first place. But there isn't really a case here that's pleaded in relation to the receipt of the representations by Relic at all, as far as I can see. You know, if you were to plead, you know, here the emails that passed on that information, or Mr. X passed it on to Mr. Y, then, you know, further particulars may be sought. But without some fact pleaded as to passing it on, I'm not even sure that you plead that it's passed on to Relic, actually. I don't think you do.
Well, I don't think, strictly speaking, it's even if the representation is made to Ready Me, it can still be relied upon by another party.
Well, they've got to know of it, and it has to be an individual then who knows of it. I mean, that's my point. Whichever way you go, it's either got to be passed on by word of mouth, by email, or whatever, or someone has to know of it in order to rely on it. But otherwise, as Mr. Patrick Joyce rightly says, you know, there's nothing to get a handle on at all as to how Relic gets involved with these misrepresentations in any shape or form.
Yeah, sure. I think the short answer is that we can have a red line pleading by the end of this week, which has that. What I would suggest is that the appropriate course after then for the defendant is to plead its defence. If it has any other issues, it's a matter for an RFI, but that the parties can thereafter, it may be that the directions need to indicate a time frame by which the parties consent or not to the joinder pursuant to Rule 20.3.
Well, that's what I was thinking of doing, trying to set out a timetable that it avoided coming back to the court, so far as I can anticipate what the position may be. But if Mr. Patrick Joyce still says, well, you haven't managed to do what you ought to do, then I can't stop him coming back and saying, I'm not having this.
Yes, well, I think the short answer is the end of the week would be fine.
All right. Okay. By close of business Friday night, draft amended particulars of claim dealing specifically with particulars of misrepresentation, receipt thereof, inducement and reliance by Relic, and facts and matters relied on in support of the fiduciary duty owed by Relic. Then, Mr. Patrick Joyce, I'm conscious that we're into a sort of August period. I don't know whether your habit is for August, but I'd be looking for some sort of date by which you would be able to revert to say, yes, you agree, or yes, you agree to joinder, but please answer the following particulars, or whatever.
Your
and
Honour,
then defence, of course.
Your Honour, yes, obviously, we'll wait to see what the learned friend says and decide accordingly. In terms of availability over August, Your Honour is right. I will be going on holiday with effect from the 3rd of August, so I think it's this Thursday, and then I'm not due back until somewhere around about the 24th, 25th of August. But
so if we were to say that you were to revert by the 3rd of September,
yes,
by the 3rd of September, defendant to indicate whether it, 1, agrees to joinder, and 2, consents to the amendments. And if there's any, or if it consents but requires further particulars, setting out what your stance is. And if you consent, then a defence and counterclaim to be produced within 14 days of so indicating. So that'd be the 17th of August, whatever, September. I may have picked a weekend, I don't know, but someone can check those dates and see if they work.
first date after, if it's a weekend, the Monday following.
Exactly so.
Yeah.
Well, we can have a look and see what they are, can't we?
Yeah, yes.
Let's look now.
Third of September is a Sunday, so 4th of September, 18th would be
4th and the 18th, yeah. 4th and the 18th, that will do. And then reply and defence to counterclaim would simply follow with the normal periods of time as per the rules.
and whilst we're looking at everything, Your Honour will be aware that we say that the documents in support of the claim, which go to both commission and expenses, which Your Honour dealt with in the previous order of the 28th of April, has not been complied with, because what we have got is in relation to commission. This is 111, 112 of my skeleton argument. What the claimant has produced is a calculation which goes to commission, but has failed to disclose the underlying documents relied on in support of its calculation, i.e. what we want is the raw material on which that calculation is based. And in relation to expenses, the claimant has not produced any calculation, and we say that's not in compliance with the order, and we repeat our request for the court's assistance in that regard. Whilst we're completing omissions which should be properly completed or rectified in early course, I'd ask for proper disclosure of the documents as per the order of the 28th of April, relating both to commission and expenses.
Well, it's the sums accepted as owing to him in respect of commission and expense. So, I understand.
I may come back on that very briefly.
Yeah. Yes, well, I was going to ask you what documents have been disclosed. I understand your problem about expenses, but
yes, so the 2 points. One is that the order is disclosure of documents supporting our calculations of the sums owing respective commission. What we've provided is our calculations of those sums. It's difficult to understand what the underlying material would be, other than every single life insurance policy entered into. I think that the purpose of the order was to make clear what we accept and what we don't. The document that's been provided is section D, tab 1.
So I didn't get that number. Page number again?
So section D, tab 1. I'm still looking for the page number because my system is going quite slowly. It's the last page in D1, I believe.
Yes, my system is similarly going slowly.
263 is the page number. So there we have a spreadsheet with each insured.
I'm not there yet. Wait.
Sorry.
Yes, I'm with you.
So we've got each insured, we've got where the transaction is, we've got who the referral party is, we've got the relationship manager, carrier, date the premium was received, how much the insured death benefits, the premiums. We've got then column A, commission, which is the total Ready Group commissions received on those. Column B is the referral fee. Net revenue is then calculated in the final tab. And then we've got compensation summary is the bottom of this, which is the calculation itself.
Yes. Now, what more do you want? What more do you want, Mr. Patrick Joyce?
Well, as I understand it, first of all, if one looks at, well, it's what we have here is simply a list of cases which involve largely Cayman, but not exclusively Cayman, because there's an entry at the top of the page which relates to Raleigh Asia, Mr. Pujara, and it's the underlying material which gives rise to all of the figures, really from the death, I assume it's death benefit, not death benefit, the column death benefit, premium, target, commission, referral fee, how all of those work through to the net revenue. And it's what is the, is it formulaic, or how has the claimant done the calculations on the base material, starting with the death benefit and the premium? So that's what we seek in relation to that. And whilst I'm speaking in relation to expenses, in one of the earlier requests for information before the matter had to be completely repleaded, and because there was a difference between legal representatives as to what should or should not be included in the bundle, and the claimant's legal representatives insisted on the earlier requests for information and replies thereto being excluded. I don't have it in the bundle, but a figure was provided by the claimant for admitted expenses. And those instructing me are about to tell me where it is. It's paragraph 66, which says the claimant recognizes that the defendant has sustained 52,667 dirham in expenses on the occasion of his employment with the claimant. And then it says no reimbursement is going to be made because a set-off is claimed. Well, we'd like to know how that admitted sum of expenses set out by the claimant in an earlier response to a request for information has been calculated. How has the AED 52,667, how's the sum of 52,667 dirham been calculated? That's what we asked for in April. That's what the court ordered in April, and that's what has not been forthcoming.
Can you just give the cost reference to that statement that amount was owing?
Yes, fortunately my instructing solicitor is here, and he's going to get the document back on screen, and I'll tell you if we go to the top of the Right at the top of it. Yes, it's claimant's response to defendant's request for further information dated the 30th of January 2023. So the request was dated the 30th of January 2023, and the date of the document, the date of the response, is dated the 17th of February 2023, supported with a statement of truth by Mr. Chin, and I think I've now provided all of it. Was paragraph 65, wasn't it? No, 66, paragraph 66 of that document.
Right. So you've got that, Mr. Doherty, in terms of production of expenses. I'm a bit troubled, Mr. Patrick Joyce, as to why you need anything beyond this schedule. This is the schedule of what they admit to be due by way of commission. If you think there's something wrong with it, then it's up to you to say so. If you want to make a further request for particulars about any particular element you don't understand, then you do that. But on the face of it, it gives you premium, it gives you death benefit, it gives you the commission, the referral fee, gives you the net revenue, and then it explains the compensation levels down the bottom, all at 30%.
Or may I take very brief instructions on that point?
Yeah, do, but on the face of it, it looks as though it explains sufficient. But take instructions and let me know.
Your Honour, the point is, and maybe it's my fault for not having fully explained it first time round, the point is that this is a document produced by the claimants, and we don't know whether it's a comprehensive document, whether it's an accurate document, because we don't have access to the underlying material which is summarised here, and it's simply because we cannot therefore test the accuracy and the completeness of what is set out here. That's the concern.
Well, I understand that, but that's further down the line. The order was that they'd provide particulars of the sums accepted as owing, and these are the particulars of the sums accepted as owing. When it comes to disclosure, no doubt you may want to ask for, you may want to have an accountant to go and look at the books or something. I don't know.
Yes, it may well be
that's a later stage.
May well be that we need to take both those steps, deal with the matter at disclosure, and thereafter by appropriate expert evidence. Yes.
Or if they've got a particular request for particulars about a figure here that you don't understand, then so be it. Or if your client thinks that, what about Mr. X, Mr. Y, and Mr. Z, then he can ask those questions, can't he? Okay.
For the time being, we're happy to leave matters there, Your Honour. Yes.
Okay. Apart from costs, is there anything else that arises at this stage? Seems to me that, like it or not, we should be meeting it again at a CMC at some stage in the future. And probably the right time is after the case has been pleaded and we have reply and defence to counterclaim and reply to defence to counterclaim or whatever. Anything else?
Probably in the circumstances, I don't think that we can set our sensible directions until we know when we're going to have a pleaded case from the defendant's side.
Yes.
So yes.
All right. Before you start addressing me on costs, what I said last time was that I thought costs reserved was appropriate, and when I said that, I meant it in relation to the 27th of April, and I wasn't going to revisit it today, or 28th of April. And I likewise think that's the appropriate order to make today, and we'll see where we get to in the longer term. If you, despite that discouragement, you wish to address me, now is your opportunity.
Yes, Your Honour, I'm not one for banging my head against a closed door particularly. There are some issues around cost, which I think trouble my client a little, which is it was, to all intents and purposes, the successful party at the last hearing. There are a number of observations you made indicating that at the course of the hearing. I seem to recall that one of the reasons why we thought we might not deal with the CMC was when we were talking about a 24th of July hearing, which would be squeezed in ahead of an arbitration you had, which I had understood and was one of the reasons I think we saw the 31st of July date. I realise we've also run over it somewhat today. However, the principle is one which still applies, i.e. costs should follow the event. There are a number of points which we would wish to make about the April hearing in particular and why it was so costly, and why there should be a substantial proportion of those sums which are allowable and should be paid by the defendant to the claimant. I note the observations about concerns on liquidity and things like that. As to that, it probably won't have escaped Your Honour's attention that in the cost schedules we've seen from the defendant so far, spent $250,000 on the April hearing. They've spent another $50,000 now. So assuming the defendant is paying his solicitors and paying his counsel, clearly liquidity is not a particular issue for him.
Yes, well, the boot's somewhat on the other foot regarding today, and I regard this all as swings and roundabouts. Much better to look at it all in the round at a later stage. And if there are points about quantum, those can be taken at a later stage too. So costs reserved again today. As claimant, can you draw up an order, Mr. Doherty, and seek to agree it with Mr. Patrick Joyce? And then when you're agreed, send it to the registry, and I can give my approval whilst you're swanning about on holiday, Mr. Patrick Joyce.
I'm very much obliged, Your Honour.
Yes, I can do that, Your Honour.
Thank you.
As you probably gather, 2013 called don't go on holiday during August anyway.
Right. Okay. Very good. If you could do that, Mr. Doherty, within the next few days, that would be helpful, because I likewise was hoping to take some time off in August.
Yes, thank you, Your Honour.
All right. Thank you both very much indeed. If you would kindly sign off, I'll have a very quick word with the associate.
Thank you, Your Honour, and I reciprocate your best wishes for what August holds in store.
Yes. All right. Thank you. Enjoy your holiday.